Pink story right now, fresh on the plate here on Ghana Tonight. Lawyers of the Speaker of Parliament, Right Honorable Alban Suman for Bagbin, have filed processes at the Supreme Court seeking to set aside the Supreme Court's orders, which suspended the execution of the Speaker's ruling declaring those 4 seats vacant. My colleague Dennis Paberi-Wadam Esquire has been looking through the documents that we have right now here on Ghana Tonight. Came through not too long ago. What are the Speaker's lawyers saying? Well,
so the Speaker is in court through his lawyers, and he's seeking to, if you like, overturn that particular order from the Supreme Court, which suspended his ruling that vacated those 4 MPs. So the prayer of the Speaker is pretty simple, that he wants that the order of the Supreme Court be set aside, and that the processes and the proceedings in the Supreme Court in this suit be set aside. He also wants that the order be vacated, and this order is in respect of the order that was dated 18th of October 2024. You remember this order that was made by the Supreme Court to the effect that the ruling of the Speaker, which vacated the 4 seats in Parliament, be suspended. The order that the MPs, the said 4 MPs be recognized. So those are the orders that the Speaker is asking the Supreme Court to set aside. Now, what are the grounds? The Speaker is simply saying that by the rate which the plaintiff had purportedly invoked the court's original jurisdiction is incompetent. He makes the argument that the process or the procedure by which the plaintiff, in this case Afenyo Makin, came to court was not proper, and to that extent is incompetent. He also says that the court had no jurisdiction to entertain the matter before it, because he argues that this is entirely a question as to the election of an MP, or as to whether the seat is vacant or not. He contends that this is for the High Court to do, and that if the High Court, in doing so, comes to a point where they think there's the need for interpretation, at that point they could refer the matter to the Supreme Court. But as it was in the case, he makes the argument that the Supreme Court did not have jurisdiction to even entertain the matter in the first place. He also continues by saying that the court has no jurisdiction to stay execution of a ruling of the Speaker of the Parliament of the Republic of Ghana. On this call, he makes the argument about separation of powers, to say that even though the Supreme Court has the power to stay execution of rulings, that does not extend to such rulings that have been made by a Speaker of Parliament, and that the Constitution clearly defines the kind of orders that the Supreme Court can stay execution on. He makes the case that this is not one of those. For that reason, the Supreme Court does not have the jurisdiction to stay the execution of that. He also makes the case that the processes and proceedings in the suits were filed and prosecuted in breach of the rules of natural justice. We all know that this was an ex parte motion. What it means is that Afenyo Makin went to court without recourse to the Speaker. He was granted that particular relief. The argument made here is that they ought to have been heard. Then there's also the other ground, that the orders of the courts dated 18th October were made in breach of the, we've seen this already, and that the orders dated 18th October were made in breach of the rules of law and procedure, which regulates the court's proceedings and orders. This, when you look at the larger extent of the explanation given here, it makes reference to how even the Speaker ought to have been served. Makes references to the immunity that members of Parliament and the Speaker have in respect of Article 117 and 118, as well as an agreement that had been reached between the Judicial Service, essentially the Chief Justice, and then the Speaker of Parliament, where they agreed that members of Parliament should be served only on Mondays. There's a document to that effect that we have seen, that in fact the Speaker had, as of 18th of October, had written back to the Registrar of the Supreme Court to reject service of the writ that was served on him. So basically, the Speaker is seeking to set aside this particular order, which sought to suspend the ruling that the Speaker made on the matter that relates to the seats of the 4 MPs who are now deemed to have vacated their seats. So essentially, the Speaker is questioning the jurisdiction of the Supreme Court in entertaining Afenyo Makin's suit. Yes. They shouldn't have even paid attention. They shouldn't have entertained in the first place. It's even questioning the process itself to say that, look, the rate that came before you was incompetent for you to have entertained it, because the rules of court have a specific way by which it should come. it makes the argument that this particular writ did not follow that particular procedure. So in the first place, it ought not to have been entertained. And finally, in concluding this, there was something interesting that the lawyers of the speaker said, that ordinarily with this kind of process, they could have come ex parte.
Right.
They think that, no, they don't want to do ex parte. The parties involved should be served. They should be ordered to come to court for the hearing. And he has gone ahead to issue hearing notices. What it means is that come Wednesday, this matter will be heard.
You mean the day after tomorrow?
The day after tomorrow.
This matter is
we'll
going to be
see whether the Supreme Court will set aside the order or to vacate its orders or not. The coming days are going to be interesting.
It's very interesting indeed. And bring in two people on this. Now, Dr. Rashid Draman, Executive Director of the Africa Center for Parliamentary Affairs. Martin Kpebu is private legal practitioner. He's also going to be joining us in a bit. Dr. Rashid Draman, good evening. Thank you very much for joining us here on Ghana tonight.
Good evening.
So that's the latest right now with this standoff we have in Parliament. The Speaker has written back to the Supreme Court questioning essentially its jurisdiction and even entertaining this suit by Afenyo Markin. And in the next 2 days, it's just the next 48 hours to watch. Again, is it not?
Yes, indeed, Alfred. And if care is not taken, this is the running battle that we are going to see between now and the end of the 8th Parliament, where, legal issues after legal issues would define the last chapter of this 8th Parliament, which is quite unfortunate. And I just heard the Right Honorable Joe Sewus, the First Deputy Speaker, and that is a view that I share, and I think that I've said this several times on your network, that this matter is not a legal matter. That the reason why we have the 275 people representing us is for them to go and sit down and talk. And that, there will be many times when things are difficult. And when things are difficult, that's when they have to show leadership. But what we see these days is the least kind of difficulty. Then people run to the court for interpretation. And, like I said before, what this does is that it only weakens the hand of Parliament, which is already the weakest link in our democratic arrangement. The executive, as we know, is so powerful. Everybody is calling for a review of the Constitution to reduce the powers of the executive. Now we are seeing a judiciary that is also very powerful. If what we are hearing from the Right Honorable Speaker right now, all the documents that you read that are before the court, questioning, why the Supreme Court is getting involved in this when it doesn't lie in the bosom of the court. It's for another level. And so, Alfred, when I sit down and think about all this, apart from, the fact that I repeat what I have said several times, this matter requires a political solution.
A political solution that must be initiated by who? There's been proposals that the president should step into this matter to call both the speaker and the chief justice, or in fact, the MPP and the NDC caucus leadership. What approach, what route should this intervention take? In what form, essentially?
Well, I think, the speaker, the chief justice, the president, need to have a conversation, maybe at the first instance, and then eventually involving the leadership of the two parties. We can run away from this for as long as we want. if this political solution is not found, we are going to end up with a situation where no work can be done in Parliament before December 7. And I think I repeat this because, if we want to use the legal approach, after one failed suit, another is going to emerge, and we are going to see an octopus of suits, if I can put it that way. That now becomes something that the courts cannot handle. And Alfred, the more I think about our constitutional arrangement and the separation of powers, which the Right Honorable Speaker made reference to, the more I ask myself a lot of questions. In the democratic architecture that we have, the courts have powers to declare what the executive or the legislature does unconstitutional. The president or the executive has the power to veto or to refuse with reasons what comes from Parliament, mostly if bills are passed. Parliament can impeach the president or censure his ministers or impeach them and so on. We saw an attempt recently on the former finance minister. But Alfred, the fundamental question is who checks the courts? Who checks the courts? And we cannot assume that the courts are perfect. We cannot assume that. They are human beings. So that when we say whatever the Supreme Court says is final, well, that's a matter of law, but as a student of politics, I'm just scratching my head and asking myself these questions. So how about when the Supreme Court is wrong? How about when when the High Court is wrong, and it passes judgment that maybe is not challenged and nobody takes it up maybe to the Supreme Court? I mean, we can't assume that these people are infallible. So I think there is some maybe the lawyers might have to think about this.
Right.
For me, I get quite worried, and I think the worry is not very much on the side of the courts. The worry is very much on the side of our parliamentarians.
I see. Well, and it's at that point that you call in the lawyers and to answer that question that you asked. So I'm going to welcome Martin Pebo right now, who's joining us. He's private legal practitioner, one of the foremost human rights lawyers we have in this country. Lawyer Martin Pebo, good evening. Thank you for joining us on Ghana Tonight.
I can see. Good.
Well, so the latest, and I'm sure you've seen all the court documents right now. The Speaker of Parliament's lawyers have filed the processes urging the Supreme Court to set aside its orders, which stop the declaration of the 4 seats being vacant from coming into force. Essentially, the lawyers of the Speaker questioning the jurisdiction of the Supreme Court and even entertaining this matter. This is one that you predicted, I recall.
Yes, that normally the right thing to do in these circumstances would be to go back to the court to ask the court to set aside the orders. Except right now, the other side to consider is that, is the court willing to eat humble pie? That's a great question to be answered. Is the Supreme Court willing to eat humble pie? Because, Mr. Kansi, I tell you, applying to the court is one thing. The court admitting that it was an error is a different kettle of fish. So that's that one that nobody can say with certainty. Unless, of course, they themselves, seeing the turmoil they've thrown the country into, they think that, okay, they'll put their egos aside and do the needful, fine. But often in Ghana, it's not something that's easy to do. You remember how when Akufo-Addo threw out into this economic crater, we called upon him to admit and accept responsibility. You see, it never came. They rather kept blaming Russia and Ukraine. Then everybody got tired after we had all shouted ourselves hoarse. Then one day, in a very lame and banal manner, he said he will accept responsibility after the horses had bolted. So that's the key thing, because Mr. Counsel, let me tell you, in the law, using the Constitution and the Supreme Court decisions of Ghana and other countries, there is equal opportunity to eat humble pie as there is to double down or dig in their heels. Yes. As for the law, that's the way it is. Depending on which perspective you are coming from,
right,
you will get sufficient language and other cases to back you. So my point is that we can't say with certainty, except maybe perhaps with the consultations that Bagbin said they were doing behind the scenes. Maybe if they reach an agreement that, okay, yes,
right,
just go back to the court and things will be made easier, sure. But trust me, it's a big hurdle for the court to eat humble pie like this, especially in the manner in which the court has embarrassed the nation with all the turmoil. But it will be the right thing for them to do, because once they've caused so much havoc, they should be ready to pay the price.
Well, we'll see in the next 48 hours. In fact, the court is set to hear this matter on Wednesday. All right, so we'll definitely be connecting again